Live stream audio test, 1, 2.
Good morning, everyone. It's now 9:30. The inquiry is resumed. I'm going to work on the basis you can hear me unless you tell me otherwise. Usual reminder, could you make sure your mobile devices are switched to silent, including me? I failed to silence my computer. Okay, that's done. Where are we up to? Well, this is day 4 of the inquiry, 2 to go after this, both next week, Tuesday and Wednesday. So far we've heard from interested parties, as well as from all of Keep Wrington as Wrington's witnesses. We've heard from all bar one of the council's witnesses, and we've got 2 of the appellants. We've heard from 2 of the appellants' witnesses. All being well today, we'll hear from Mr. Reynolds for the council, their final witness, their planning witness. Then we'll hear from Ms Armstrong, the appellant's heritage witness, thereby leaving 2 witnesses who will be heard, all being well, on Tuesday of next week. In terms of, before any of that, housekeeping, there was the easement point, Mr. Boyle. Is there an update on that?
So we now have copies available for everybody, thank you.
Okay, thank you. Those can be distributed now, please. Was there anything else from anybody? Nothing was on my mind. Oh, but what's one thing? There's a slightly enigmatic blue wallet to my right, and I suspect, I've not touched it, I don't know what it is. I suspect it's left over from whatever happened in here on Wednesday. But I'm getting lots of blank looks, so it's evidently nothing to do with us. And yeah, it's just there. It's quite intriguing. I've been tempted to pick it up and look at it, but I haven't, and I never will now by the looks of it. The mystery of the blue wallet. Anyway, okay, we'll move on to your final witness then, please, for the council, Mr. Wadsley.
Yes, yes. Thank you very much, sir. It's, of course, Mr. Mark Reynolds, and he is in place. I'll introduce him from his main proof of evidence, and then we'll look at his summary proof. Mr. Reynolds, it's Mark Reynolds, is that right?
That's correct.
You tell us you're a Director of Context Planning Limited, position you've held since November 2018. By way of qualifications, you have a BSc Honours degree in Physical and Human Geography from Reading University, an MSc in Spatial Planning from Oxford Brookes University, and you've been a fully chartered member of the Town Planning Institute since 2008. And as to your experience, you tell us that before becoming a Director of Context Planning, you had over 15 years' experience working for councils in the South West Wiltshire and Bath and North East Somerset Council in particular, in various capacities. Is all that correct?
Yes.
Thank you very much indeed. Good. Can we deal with this by going to your your summary proof of evidence? And I'm going to invite you to read. It's not all of it, I don't think, because some of this is uncontroversial. Perhaps if you'd, then I shall be asking you questions, supplementary questions to deal with various matters that have arisen. So, if you'd start with your summary proof from, let's say, paragraph 3, please.
So, starting at paragraph 3, policies CS14 and CS32 are drafted in terms to ensure that small-scale developments come forward in service villages under the current development plan. These settlements only have capacity for limited levels of growth, given their lack of self-containment, limited services, facilities and supporting infrastructure. The Core Strategy Inspector fully endorsed the Council's approach to distributing housing within the settlement hierarchy. The appeal proposal greatly exceeds the identified limit of up to 25 dwellings, which might be brought forward under the terms of Policy CS32 outside of the plan-making process. The development cannot be considered to be small-scale and runs contrary to the adopted spatial strategy of limiting levels of growth at service villages to that which is sustainable. Wrington is already in the process of receiving a large development of 59 dwellings, which considerably exceeds the small-scale forms of development proposed for the service village. A further outline permission for up to 38 dwellings at Gatcombe Farm, just outside the village, has also been approved. Excessive levels of growth in service villages may result in unsustainable transport patterns and could prejudice the delivery of housing sites at larger settlements which accord with the spatial hierarchy, which would be better suited to sustainably accommodate a development of this size. The appeal site, in part, adjoins the settlement boundary of Wrington, but it does not do so continuously. Allowing this appeal may promote further residential development on the piece of land which would become surrounded by housing, compounding and exacerbating the inappropriate scale of development for the settlement. The appeal site has been put forward as available for development through the plan-making process, but was not allocated through the Sites and Policies Plan Part 2, Site Allocations Plan 2016. The planning application drew significant public opposition with 820 objectors. There appears little prospect of the development forming part of a neighbourhood plan allocation. If allowed, development of this inappropriate and harmful site for a significant amount of housing would subvert the plan-led process, which is the proper means for sites of this size to come forward in a context where there is little prospect of the site being formally allocated. In my main proof, I've identified a number of appeals in North Somerset where the inspectors have dismissed appeals. In each case, the council was unable to demonstrate a 5-year housing land supply. Despite this, the inspector in each case concluded that the various harms they identified, which included the harm done to the council's locational strategy, significantly and demonstrably outweighed the benefits of building houses on the site and any other benefits flowing from the various schemes. The same is argued to be the case in this appeal. If allowed, this appeal decision would undermine the plan-making process. Significant opposition exists to this particular appeal proposal, and it would be most unfortunate if a decision is in direct conflict with the government's desire to involve local people in plan-making were made, which would also be likely to reduce confidence and public engagement in future plan-making.
Could you, excuse me, could you just pause there for a moment, please? Because what I want you to do is to consider, first of all, policy CS32 and policy CS14. If you have the core documents in front of you, and if you could turn, please, to A1, which is, of course, the core strategy, and let us just look briefly at what CS32 says. But I'm going to ask you to go to the local plan inspector's report in relation to that. So if we look at CS32 first, which is on page, I'm the one who gets page numbers wrong, but let's say it's page 130 of the core strategy. And it tells us about new development, does it not, in service villages. And it tells us that new development within or adjoining the settlement boundaries of the service villages of, including Wrington, which enhances the overall sustainability of the settlement, will be supported where? So pausing there for a moment, is there any issue over whether the proposed development adjoins the settlement boundaries?
The appeal site, in part, adjoins the settlement boundary, but there is a parcel of land, a paddock, which doesn't form part of the application site, which sits in between the appeal site and the housing development boundary for Wrington.
And then if we look at the various criteria, I don't ask you to go through each one of them, but what I'd like you to tell the inspector, please, is if, in your view, there are any of these criteria which the development could be regarded as not complying with or offending.
Yes, so the policy is obviously caveated based on compliance with the bullet points that you see on page 130, and I say that this development infringes bullet point 1 and bullet point 4 of on that list.
Just tell us briefly how.
So the development is of a form, design and scale which is not high quality, fails to respect and enhance the local character would not reinforce local distinctiveness and cannot be readily assimilated into the village. So that's the first, my comments on the first bullet point. Bullet point 4, I don't consider that the development is a high quality sustainable scheme, which I consider is inappropriate to its context and would fail to make a positive contribution to the local environment and the landscape setting of Wrington.
Okay, thank you very much. If we can just look briefly at CS14, going backwards, and that's at page 60, oh, sorry, beg your pardon, before we go to CS14, my fault. If we look at the concluding words of the policy, sites outside the settlement boundaries in excess of about 25 dwellings must be brought forward as allocation through local plans or neighbourhood plans. And of course, this development is for 61 houses. Okay. If we then go back to CS14, please, which is page 67, there again, we can see that it's about distribution of new housing. It deals with Weston-super-Mare and then the towns of Clevedon, Nailsea and Portishead. And then at service villages, there will be opportunities for small-scale development of an appropriate scale, either within or abutting settlement boundaries, or through site allocations. Again, how does that tie in, if you like, with CS32?
CS14, paragraph 4 clearly references that at service villages there will be opportunities for small-scale development of an appropriate scale, either within or abutting settlement boundaries. So CS14, as you say, deals with the distribution of housing within North Somerset. It's clear from that that the spatial strategy is that small-scale developments may be appropriate in service villages.
Thank you very much. I want to see how the local plan inspector dealt with this, and that, I think, is... it's core document A4, please, which is the local plan inspector's report about the main modifications which resulted in, amongst other things, CS32. So if you would go to A4, please, and there, dealing with CS32, it's page 18 of the local plan inspector's report. The inspector at paragraph 70 on page 18 deals with his main modification 05, and that appears in the next core document A5. I'm not going to suggest we need to look at the text unless some issue arises about it, but it appears to me, having looked at it, that MM05 is indeed policy CS32. So on that basis, we can see that paragraph 70 says that MM05, policy CS32 as it became, strikes the right balance by supporting new development within or adjoining the settlement boundaries, whilst ensuring that the form, design and scale of development respects the local character and reinforces local distinctiveness, and so on. Then it says it also aims to limit cumulative impacts and indicates that sites in excess of about 25 dwellings outside the settlement boundaries must be brought forward as allocations. Now, the local plan inspector then deals with that point and how that chimes in with planning policy. So if one looks at the next sentence, it starts by saying this is neither too restrictive nor too liberal. It's a sound modification, etc. What do you derive from that in terms of support for the rationale behind a policy like CS32?
Well, I consider in reading that paragraph that the core strategy inspector considered that sites of around or up to around 25 dwellings could be appropriate in service villages to enable additional flexibility in terms of housing delivery, and that around developments of around that size and not exceeding that was a good balance, described as obviously neither too restrictive nor too liberal, and that it would allow the council to deliver its spatial strategy without resulting in developments of an excessive scale occurring in service villages which are designed for small-scale developments.
Okay, we'll look at paragraph 69 now, and let's just look at the, we need to look at the whole paragraph, but look at the first sentence where the inspector says, neither significant restrictions on housing development nor substantial amounts of additional housing represent a sound or balanced approach towards settlements which contain a range of services and facilities, but which are in essence still villages. How does that comment, in your view, apply to Wrington?
In the case of Wrington, I consider this is particularly relevant because Wrington has fewer services, facilities, public transport connections in comparison to all but one of the other service villages within North Somerset. And in that regard, excessive levels of housing in Wrington might well lead to unsustainable patterns of development, the kind again, of which that the core strategy inspector guards against in suggesting the modification.
Yes, the inspector then goes on to refer to service villages as being capable of handling without harm a range of smaller schemes within or adjoining their settlement boundaries and designed in keeping with their surroundings. And he goes on to say there will be opportunities to make a contribution to the overall housing requirement whilst meeting some local needs and helping to support local facilities. He then refers to development of a modest scale adjoining settlement boundaries, no reason why they should threaten the character of the villages. Then he goes on to say, however, larger scale schemes or substantial cumulative growth will be more likely to alter the character of the villages, place undue burdens on infrastructure and the road network, and threaten the spatial strategy. It's not without reason, he says, that these concerns have been raised by a number of communities. Again, that comment in relation to Wrington, how do you say that fits in with what we've got here?
Well, I say that in the case of Wrington and this particular appeal proposal that the council identified harm to the landscape, harm to the setting of a Grade 1 listed building, and that is in part driven by the scale of development that's being proposed, and that needs to also be considered having regard to existing permissions within the village as well, having regard to the issue of cumulative growth. But yes, that would potentially place undue burdens on infrastructure, and this type of development, the appeal proposals, threaten the council's spatial strategy for service villages, and that particularly resonates in the case of Wrington, given that it is one of the smaller service villages.
I'll come to issues of transport separately in a moment. But just give us, if you can, give us an overview. How does Wrington compare, for example, with service villages like Backwell or Yatton?
So Wrington itself, in terms of facilities that it has, those have actually declined since the core strategy was adopted. At that point, there was a GP's, a bank, a garage, and also there were school places in the primary school within the village. All of those things have changed since that point. Yatton, for example, is about 3 times larger than Wrington. It has all of the facilities that Wrington has in general terms, but it also has a doctor's, a library. It's got a local centre of over 50 shops. It's got a medium-sized supermarket, several banks, and it's also got a half-hourly service to Bristol and Weston-super-Mare on the train that runs from 7 in the morning till 11 in the evening, and it's got an hourly bus service to both of those destinations as well. In the case of Backwell, that is about twice the size of Wrington. It's obviously geographically located very closely to Nailsea, and it was identified in the core strategy evidence base as being the most sustainable of the service villages. That Backwell itself has around 40 shops, 4 restaurants, it's got a primary school and a secondary school, and like Yatton, it also has a half-hourly service on the train from early in the morning till late in the evening to Weston-super-Mare and Bristol. So I would say that Wrington compares unfavourably in terms of services and facilities in comparison to those larger service villages.
Okay, thank you. If you could go in the core document we've been looking at to what the inspector dealt with in dealing with CS14, and it's pages 12 and 13 of that document. If we look at paragraph 37, well, perhaps paragraph 34, first of all, the last sentence, the inspector's dealing with the hierarchy there, and he says in the last sentence of 34, increases have also been allocated to service villages, but these villages are still allocated a considerably smaller proportion of the overall total. Again, he says this is right because they are notably smaller with lower order facilities. So with that in mind, look at paragraph 37, please, about halfway down the paragraph, where a third of the way down the paragraph perhaps, where the inspector starts, it is true that some schemes in excess of these figures, that's the figures he's referred to immediately above, have in the past been granted permission on sites in Yatton and elsewhere. But the council is perfectly within its rights, in the interest of the proper planning of the area, to put a figure on the maximum site for individual developments on unallocated sites and so on. Again, as far as that is concerned, how does that fit in with what is the position in the service villages and the nature of schemes that can properly be brought forward?
So yes, in service villages, the spatial strategy as presented seeks around 10% of development to take place within the service villages. So they are supposed to provide a modest contribution to overall figures. The paragraph 37 and the references there to the sizes of developments which could be appropriate at the edges of the settlement, that is tailored down from Weston-super-Mare as the largest settlement at 75, and then obviously Cleveland, Nailsea and Portishead at 50, and then service villages at 25. That to me seems an entirely sensible strategy, given that Weston-super-Mare, Cleveland, Nailsea and Portishead clearly offer better opportunities for larger scale developments to be sustainable.
Okay, thank you. And on a linked but separate topic, the appellants point out that there is a bus service from Wrington. Can you help us with the nature and frequency, which is not referred to in their evidence, but can you help us with the nature and frequency of the service?
So if we go to the statement of common ground transport, just let my computer catch up. That's pages from page 28. So appendix, bus timetables and routes. And then you'll see there you have the number 51 bus service. So that is a bus service which links Weston and Wrington. So in terms of what you're looking for in the names, it's Golden Lion there. That's the bus stop within Wrington. So you can see it's number 51. The first bus Monday to Friday, but it also operates on a Saturday on an identical timing, but there's no bus service on a Sunday. So the first bus leaves Wrington at 8:45 in the morning and would arrive in Weston at 9:39. And the last bus back from Weston leaves at 16:45 and gets back at 17:38. So I would say in that regard, the bus service is on a roughly 2-hourly frequency. So I would say the bus service is quite limited and doesn't offer opportunities for journey to work trips.
No. Have there been other bus services in the past that you're aware of?
Yes, there was previously a bus, the A2 service, which is run by First, and that was a bus service which linked Weston-super-Mare to Bristol Airport to Portishead, which did stop in Wrington. That bus service ceased operating in 2018. That bus service ran on an hourly frequency and ran from early in the morning to quite late into the evening. And there was also a further bus service which has ceased, which was the A5 bus service, which linked Winscombe to Langford to Bristol Airport and on to Winford. That A5 bus service was on a roughly 2-hourly frequency on a Monday to Saturday.
Does it still run?
No, it doesn't run.
And so far as buses are concerned, how does that compare, for example, with Backwell or Nailsea?
So Backwell has an hourly bus service that links it to Bristol and Weston-super-Mare, and that service runs for longer hours than this service which serves Wrington and number 51.
Thank you. Okay, we got as far as paragraph 11. Would you like to read on from paragraph 12, please?
Yes, I'll read on. I should say in paragraph 12 there is a mistake which I should correct at this point, that's carried over from my proof of evidence into the summary. It's the same sentence, and it's the sentence which begins, if the appeal were to be allowed, the rural landscape which forms an important part of understanding the significance of the heritage asset would be irrevocably lost, and the significance of the heritage asset would be significantly harmed. That is incorrect, and that's inconsistent, obviously, with the council's case as put at the proof of evidence stage. That should say, if the appeal were to be allowed, the rural landscape, which forms an important part of understanding the significance of the heritage asset, would result, and less than substantial harm would result to the heritage asset. So I make that correction, and as I say, that's carried over. That's also in my main proof of evidence, and that's carried over in preparing the summary proof directly from the main proof. So, paragraph 12, the effect of the proposal on the setting of heritage assets is dealt with in the evidence of Dr. Hudson Macaulay. She concludes that the proposal would harm the setting of the Grade 1 listed Church of All Saints. I agree with and adopt her conclusion. The setting of the church and the views towards it contribute to the significance of the asset. If the appeal were to be allowed, the rural landscape, which forms an important part of understanding the significance of the heritage asset, would be harmed, would result in less than substantial harm. Great weight must be applied to the conservation of this heritage asset, which is as a Grade 1 listed building is an asset of the highest significance. The less than substantial harm which would result to the heritage asset would not be outweighed by the public benefits associated with the appeal proposal. I consider this constitutes a clear reason for refusing the appeal proposal, and consequently the tilted balance is not engaged. As explained in my proof, the proposal would be contrary to CS Core Strategy Policy CS5 and Policy DM4 of the Sites and Policies Plan Part 1 and the advice contained within the MPPF. The effect of the proposal on the character and appearance of the area is dealt with in Mr. Etchell's evidence. He He concludes that the appeal proposal will have a significant adverse impact on the landscape character and localised views. I concur with and adopt his conclusions in this regard. The landscape sensitivity of the site and adjacent land to the west, south and north is assessed as high in the North Somerset Landscape Sensitivity Assessment 2018. The land is open, visually prominent and lacks landscape features which could potentially limit development sprawl. The land provides an important rural, pastoral setting to the village, and the projection of built development to the west and south would irrevocably erode this character. The introduction of a large residential estate lacking opportunities for adequate landscaping would be prominent and harmful in views. The appeal proposal would cause significant harm to the character and appearance of the area and would be contrary to core strategy policies CS5 and CS32 and policies DM10 and DM32 of the Sites and Policies Plan Part 1 and the advice contained within the MPPF. The Council accepts, as outlined in Mrs Richards' proof, that it cannot demonstrate a 5-year housing land supply, but the extent of the shortfall will be better known before this inquiry opens. The most important policies for determining this appeal should all be afforded substantial weight, given they align closely to the guidance of the MPPF.
Just pause there for a moment. Of course, we know from the appeal decisions that we've had since the preparation of the proofs of evidence in this inquiry, what the position is. You might just like to comment briefly on what the Section 78 inspectors have dealt with in respect of housing land supply.
So yes, the issue of housing land supply has arisen in a number of recent appeals, which have been determined subsequent to the preparation of the proofs of evidence. 2 appeals in Yatton, one for an allocated site, one not for an unallocated site, and then one site in Backwell. In those cases, the issue of housing land supply was discussed through the process and sites were considered. The appeal inspector, in respect of the Yatton case on the unallocated site, determined that the council could demonstrate a 3.2-year housing land supply, and the most recent decision in respect to the Backwell case, it was found that the council could demonstrate around a 3.5-year housing land supply. So the council has and does accept that it cannot at present demonstrate a 5-year housing land supply.
Okay, I'll come to that in a moment or two. Would you like to read on, I think, from paragraph 17, please?
In terms of the benefits of the proposal, I attach significant weight to the benefit of both delivering up to 61 dwellings and to the fact the appeal proposal makes provision for a policy-compliant figure of 30% affordable housing, up to 18 number units. The provision of jobs in relation to the construction of the development comprises a temporary economic benefit of limited weight. I attach moderate weight to increased expenditure in the locality which would result, but do consider it difficult to predict where this expenditure would take place and the degree to which it would be in the locality, which somewhat tempers this. I attach very limited weight to the benefit of the provision of open space and surface water runoff drainage arrangements, which I consider to be required to offset the impact of the proposal. The provision of a 10% net gain in biodiversity is a benefit to which I attach moderate weight. Against these benefits, the appeal proposal would result in an unsustainable form of development, contrary to the clearly expressed adopted settlement hierarchy within North Somerset. I attach significant weight to this identified harm. The proposal would result in less than substantial harm to the setting of the Church of All Saints, which would not be outweighed by the public benefits of the proposal. I attach substantial weight to the harm which would result to the setting of the heritage asset. The proposal would also have a significant adverse impact on the landscape character and localised views, harming the character and appearance of the area. This harm would be very significant and I afford it substantial weight. I conclude in this case that the tilted balance is not applicable by reason of subparagraph 1 and associated footnote 7 to MPPF paragraph 11. In the alternative, if the inspector considers there to be no clear reason for refusal and that the tilted balance is engaged under MPPF paragraph 11D2, then I conclude that the adverse impacts of granting permission in this case would significantly and demonstrably outweigh the benefits of the appeal proposal when assessed against the policies in the MPPF taken as a whole. I therefore respectfully invite the inspector to dismiss the appeal, whether it benefits from the presumption in favour of sustainable development or not. Appeal B is not contested by the Council on the basis that the Council would have approved the application. A Grampian condition has been suggested in terms of its implementation.
Just one more matter to pick up on. In your main proof of evidence, you deal with the planning balancing conclusions at page 26 and following. And I just want your help with the question of ecological mitigation and well, let's deal with ecological mitigation first. You say moderate weight rather than anything higher. Why is that?
I say moderate weight because I do think there is some benefit because the appellant's seeking to go beyond the 10% figure, which is obviously has been brought in through the Act, but not yet implemented through secondary legislation, but is being quite widely, in my experience, adopted by councils, having regard to the MPPF guidance about seeking to maximise biodiversity net gain. So I do consider that there is a moderate benefit there in that this goes beyond that, but having regard to the scale of what's proposed, I wouldn't go anywhere, wouldn't go beyond moderate.
Okay. And in relation to improved management of surface water runoff, you attach very limited weight. Now, it might be said that's a very considerable benefit, but why do you attach very limited weight?
Again, I give that very limited weight because I think that is principally required to make the development in itself acceptable. The development couldn't be acceptable unless it can deliver some improvement in that regard, and this scheme does that. So I would give that very limited weight.
Thank you very much. Is there anything else you wanted to say about any of the benefits and harms to which you've attributed weight?
Yeah, I think I'd like to say something around the weight to the benefit of housing delivery. I think from considering the appeal decisions which have come forward, I think that, and the clarification in particular around the degree of shortfall of housing land supply, does to me indicate that the weight to be attached to that has increased, or the weight that I attach to it has increased now that the extent of the shortfall is clear. But I don't say that it goes beyond, I wouldn't give it more than significant weight in this case, and that's for several reasons. In particular, the housing proposed in the location that is being proposed at the edge of Wrington, to my mind, would deliver less benefits in terms of its sustainability credentials than the housing, for example, being delivered, or that would be delivered in Yatton and Backwell through the recent appeal decisions that we've heard. As I've said, Wrington itself is categorised as a service village, which can accommodate small-scale development. But as we've heard from Keep Wrington as well, their facilities in the village have declined, even since the Cox's Green decision, which was also at the edge of the village. So services have declined. As we said, we've lost the GP, a full post office service, banks, the petrol station, opticians and various shops. And we've lost 2 bus services, and we no longer have a journey to work bus service within the village. So the benefits that I afford to housing on the edge of a settlement such as Wrington would be less than I think should be attributed to a settlement, a larger settlement, which is more sustainable in simple terms.
Thank you. Anything else?
In terms of the public open space, I note that the draft Section 106, which is now signed, I note that Section 106 agrees to meet the minimum requirements of the council as regards the type of open spaces that should be provided at the site. I've given that limited weight, or very limited weight, and the appellants give it increased weight. But I consider it is principally, again, required to mitigate the effects of the development. And in particular, the way in which it's delivered, in that it is largely required, the areas that were identified are largely required for landscaping measures to screen the development, and for drainage features, and those areas in particular, other than the leap, are effectively linear, narrow spaces at the peripheries of the site, with very limited potential, in my view, to actually act as beneficial public open spaces. I also consider the location of the site at the southern tip of the village to be such that I think it's unlikely that users from outside of the development would be inclined to make the trip there to use these particular facilities. But I do afford it limited weight because I do recognise that the leap in particular is located relatively closely to an existing cul-de-sac, and so that there might be some potential for that to be used by those who aren't resident in the development. I also think that Wrington's relatively well served for open spaces, and the sports and leisure club to the east is more of a draw for people looking for outdoor spaces.
Thank you very much. Will you stay there, please? I've no doubt you'll be asked other questions.
Yes, can we go to cross-examination, please, Mr. Boyle?
Thank you, sir. Mr. Reynolds, good morning.
Good morning.
Mr. Reynolds, you're not a council officer, you weren't the case officer, you're a consultant brought in to assist the council in presenting evidence to the inspector.
That's correct.
And as such, you're constrained in two different directions, aren't you? You're first of all constrained in your own professional judgment. In other words, you can't give evidence that's contrary to your professional judgment.
That's correct.
You're a member of the RTPI, after all. And secondly, you're constrained by the council's case. That is, you might have all sorts of exciting reasons why you think the scheme shouldn't go ahead, but if they step outside the proper remit of the council's case, they're not relevant to the matter upon which you speak, which is the council's reasons for refusal.
In looking at the case and in determining that I could act on the case, I clearly had regard to the concerns and reasons for refusal outlined, and consider that yes, I can act on the case and agree with that position. Yes,
that's the first constraint. I'm on the second constraint now. You might have all sorts of reasons why you think the scheme shouldn't go ahead, but insofar as they step outside the council's case, that's not relevant to your instruction.
Yes, I'm here to defend the council's case, yes.
Thank you very much indeed. I'm grateful. Good. Can we just take up your proof? I appreciate there's a correction you helpfully made in your rebuttal, your summary, but we need to read that through into the proof itself, don't we? And I detected the location of the correction. Is it paragraph 525 on page 22? This is reason for refusal 1, heritage impact on the Church of All Saints. And the phraseology about rural landscape being irrevocably lost and the significance being significantly harmed, that's the bit you corrected in your summary, is that correct?
That's correct.
So we would now have it read that the rural landscape would be harmed, and, as you put it orally, there would be a less than substantial harm to the significance of the heritage asset.
Yes.
That's consistent then with Dr. Hudson Macaulay's evidence. Yeah. And just while we're here, we can actually add a bit more now, can't we? Because courtesy of the Statement of Common Ground and indeed oral evidence, whenever it was yesterday, it's at the lowermost end of the scale within the less than substantial harm category.
That's correct.
Thank you very much. So we'll notionally or actually write that in. Thank you. Let me then go to your issues, which you set out helpfully at your paragraph 3.1, and there are 5 that you've identified for us. The first being the effect of the proposal on the spatial strategy for housing development and settlement having regard to CS13, CS14, and CS32. Yeah.
Yes.
The second, if I can do it roundly, is the heritage point, which is reason for refusal 1.
Yes.
And we know that's now limited just to the impact on the church, or the significance of the church, not the conservation area. That's reason for refusal 1. The third, if I can get it in round terms, that's the landscape and appearance point. That's reason for refusal 2.
So reason for refusal 2 covers 1 and 3 in my list.
I beg your pardon.
Reason for, so number 3 on the list at 3.1, that is, yes, that is the landscape objection. But my objection, or the council's objection, in respect to point 1 at 3.1 is also covered in the second reason for refusal.
You are saying that your issue 1 is a landscape issue?
No.
Well, reason 2 is a landscape reason for refusal. So is issue 1 limited to landscape, or is it wider?
No, reason 2 is wider. It does refer to the spatial hierarchy as well.
Yes, in terms of landscape. The scale being too big for the landscape.
The council's case is that there is harm to the landscape, and that is part of reason for refusal 2.
Yes.
But also, and the reason for refusal 2 does deal with the point around whether or not the development is in compliance and harms the spatial strategy of the council.
Well, we'll need to explore that in a moment. Can we just go to your issue 3? Issue 3 is a landscape point.
Yes.
Thank you. And it derives from reason 2.
Yes.
Thank you. Issue 4 is 5-year land supply, which has now been resolved for the purposes of this appeal to the satisfaction of the parties. There is now a range. I know the appellant contends with something like 2.95 years. Inspector A has found 3.2, Inspector B has found 3.5, and the parties are content that our inspector doesn't need to decide between those figures. There isn't a 5-year land supply, and the shortfall is material.
That's correct.
I'm grateful. So that's been resolved. That's issue 4. And then issue 5 is what, well, it's expressed essentially as a section 38.6 balance, is what we call the planning balance.
Yes.
Which, of course, you speak to as the planner.
Yes.
Yeah. Issue 2, therefore, I have taken it that you rely entirely upon the expert evidence led by your authority. That's from Dr. Hudson Macaulay.
I do.
I'm grateful. You don't seek to add to that, you rely upon it, and so you're fixed, if I can put it that way, you're fixed by that evidence, which you then take into account.
Yes.
And that is, we just identified the evidence, which is there is a less substantial impact on one asset at the lowermost end of that scale.
Yes.
Thereby triggering paragraph 202 of the MPPF. Yep.
Yep.
Which, as we discussed with Dr. Hudson Macaulay, but you readily agree as the planner, if 202 is passed, the scheme, that's the inspector's judgment, if 202 is passed, the scheme becomes national policy compliant in heritage terms.
Yes.
Good. Similarly, issue 3, landscape and visual impacts, you rely upon the expert evidence led by the council.
Yes.
In that case, what's his name now? The witness for the council. And again, you don't seek to add to that.
No.
And you'll recall in terms of the, there was a comparator tables. Do you remember I call them the blue sheets?
Is that in the statement of common ground?
No, it was done separately, but there were two comparative. Oh, of course, you weren't here, were you? I'm so sorry. There are two sheets, blue sheets, which are agreed as representing the respective positions of the parties. I'll rehearse the matter very briefly with you because you weren't here. All others are very familiar with this. Now, if you look to the first of those concerning landscape character, you want that? Landscape character.
So I've got, landmark practice viewpoints related to LVIA considerations. I've got two identical sheets.
Oh, you should have two different sheets. It's coming over. You there, landscape character? And if you look to the second entry, you should find site and environ. Environment.
Yes.
Got it? And the first row is the council's position, Mr. Etchell's, JE.
Okay.
Got it? And if you go right away across to the far side, you'll find year 15, significance of effects. You got that?
I've got it, yep.
Moderate.
Moderate adverse.
Yeah.
Yep.
Thank you very much. So that's as far as the council's expert puts it at its highest. Obviously, we differ from that, but that's for the secretary to judge and not for you to re-explore now. Council's expert at its highest, year 15, the site and its environs, landscape character impact, moderate. Yeah. And the other piece of evidence, which again I hope has been communicated to you, but in any event is in the written text, is that that's in respect of a site which does not form part of a landscape which is a, quote, valued landscape for the purposes of paragraph 174A of the MPPF.
Yes.
You're familiar with that? Yeah, good. So again, you are, as it were, fixed with that evidence. That's the highest the council puts its case on landscape. It's a moderate landscape character impact on a and I use the term as a term of art, a non-valued landscape for the purpose of paragraph 174A of the MPPF. Yeah?
Well, only in regards to when the point at which you reach 15 years. The council's case is that impact would be moderate high for the first, well,
Yeah.
till that point in effect. So
We see that recorded. I'm not going to go back over that. Thank you very much indeed. Okay, so that's issue 2 and issue 3 in terms of how you approach it. And just an observation in chief. When you went through the criteria of CS32 and identified bullet 1 and bullet 4, and you read those out, the harm or the failure to comply, as you put it, with 1 and 4, I take it derive from the issues raised under Refusal 1 and 2, the heritage impact and the landscape impact. You are not here giving, for example, evidence on design, the quality of the proposal, what might or might not happen at reserve matter stage, the way in which the design and access statement will inform that and the council's determination of that, are you?
So yes, in respect to bullet point 1, bullet point 4, and then the final or the penultimate sentence, sites outside the settlement boundaries in excess of about 25 dwellings.
Well, I'm going to come to that point with you, don't worry, in a moment. But 1 and 4 derive from reasons 1 and 2, don't they? Your objection on 1 and 4. You're not giving separate, different design evidence, for example, are you?
No, I'm not.
No. And indeed, again, because you weren't here, you may not have been listening in to the YouTube. It's been recorded for the inspector that the authority expressly does not take a design objection, has no objection to the manifestation of the built form or any of the detailing that is proposed, which will come out at reserved matters stage, the approach to placemaking, the beauty agenda, section 13 of the MPPF, etc.
If it were accepted that the principle of 61 dwellings on this site didn't harm the landscape and the setting of a listed building, then yes, in terms of how that can actually be manifested.
Thank you very much indeed. So, CS32, bullet 1, bullet 4, the case that you identify is reference to reason 1 and reason 2, heritage and landscape, and for those you rely upon the relevant experts rather than giving your own separate evidence. If I then go to your text, just so we can see how you structure matters thereafter, your case is set out at section 5. It starts on page 14.
I have it.
You have that. And 5.1 running on right the way through to 530 on page 23. That's directed to, I'm so sorry, I've given you the wrong reference, to 522 on page 21. That's directed to your first main issue.
Without rereading the whole of it, I couldn't
just
say
look at
certainly that it doesn't deal with any other issues.
Just look at the headings.
Yeah, okay, so we go on at 523, effect on the listed building.
Exactly. So the preceding paragraphs, 521 to 522, that's all your first main issue. Yeah.
Yes.
Then you cover the second main issue, 523 to 530. That's heritage.
Yes.
Again, relying upon the expert witness. Then character and appearance, 531 to 536 is your third main issue.
Yes.
Then we get to 5-year land supply, which we can now add in the figures.
Correct.
And then we turn to the planning balance in section 6.
Yes.
Yes, good. Now, you deal in section 6 with benefits first, and then with harms. Yeah.
Yes.
And if we read what you've said in terms of harms, 612 is the landscape point. So that's reason your issue 3.
Yes.
611 is your issue 2, it's the heritage point.
Yes.
610 is your issue 1.
That's correct.
And what you tell us is, as a result of issue 1, and I'm assuming as a result of the text which you set out from 5.1 to 5.22, which is all your own, not relying upon any other expert witness, as a result of 6.10, you say there is a harm, and it's a harm of significant weight.
Correct.
And you place that in the planning balance against the benefits.
Correct.
Yeah. It's one of 3 harms, but it is one of itself significant weight.
Correct.
Yeah. Let's just look at what you've given us at 610. Unsustainable form of development, contrary to the clearly expressed adopted settlement hierarchy, the size greatly exceeds what may be described as small scale, allowing people to harm the locational strategy. Also undermine the importance following a plan-led system in a case where plan-making process has not identified the site as suitable for large residential development. It would prohibit local people from properly engaging in the plan-making process as regards where to locate a significant major residential development, and you attach significant adverse weight to that.
Yes.
There is no reason for refusal supporting the propositions in 610, is there?
So it's reason for refusal to.
Which is a landscape reason. You want to go to it?
Yes.
Find it in a variety of different places. I'm going to take it up from the Statement of Common Ground, where we'll look at some other passages too. It's paragraph 1.7 of the Statement of Common Ground. Now, you know, as we approach...
Sorry, Mr. Boyle, I'm
so
still
sorry.
looking at it. It's not in the core documents list, it's on the website, isn't it?
Yes, Statement of Common Ground.
Sorry.
You will need this document a lot.
Yep. Hang on, I need to reload my computer.
That's all right, don't worry at all.
I have it, yes.
Good. You know, as we approach this, that the Council, first of all, speaks by resolution.
Apologies, which paragraph was it? I've got the
1.7,
document.
1.7, page
yeah.
1.
Okay.
And we're looking at reason 2. The Council speaks by resolution. Yep. Yes?
Yes.
And the Council, in resolving to refuse planning permission, issues reasons for refusal to inform the recipient and the wider world as to why it's done so.
Yes, along with an officer report to explain it.
Yes, I'll come to that as well. And the guidance is very clear, isn't it? Those reasons must be clear as to what it is that is being said to be objectionable about the scheme. And you will be aware of the guidance in terms of cost consequences of seeking to add further issues hereafter. Yeah?
Yes.
Good. We'll bear all that in mind and see where we go with it. You mentioned the committee report. That's CDD.2. You have that?
It's not, they're in the incorrect order, D1 and D2, but I've got it, yeah.
You've got the committee report. I have it recorded as D.2 if it's been slipped.
It's,
I've got it down as D.2, but I've looked at it I have it somewhere else, so I don't actually have the core doc in front of me. From the list, it's D2, I think. Is it D1? No, I've got D1 as decision notice, and D2 is officer report, but maybe they've been swapped around. Yeah. Either D1 or D2, wherever you happen to find it, Mr. Reynolds.
I have it, yeah.
Good. Thank you very much indeed. If you go to the end of the committee report, you will see recommendation, refuse, see draft decision for reasons.
So recommendation, page 20? Yeah.
Yeah, got it? Draft decision for reasons. And whichever it is, the D1 or the D2 in your list, you should find the decision notice that gives the reasons.
Yes.
Good. And they are as set out at paragraph 1.7 of the Statement of Common Ground between those on behalf you appear and those on behalf I appear.
Correct.
Good. If one goes, have you read the committee report?
Is it, I've read the delegated report.
The delegated report, yeah?
Yep.
One goes through that. After a series of long sections of bullet points, on page, in my version, page 8, you got that?
So your page 8, yeah, it starts with a long list of bullet points.
with a heading conclusions.
At the base of page 8.
The bottom of the page, that's right.
Yes, yeah.
And then over the page, we've got principle of development.
Yes.
CS14 sets out the settlement hierarchy, special approach to housing district. CS32 states that new development up to 25 dwellings supported adjoining settlements subject to several criteria. These criteria notwithstanding, the proposed development is up to 61 dwellings, clearly excess thresholds by CS32. In this respect, its comprehensive development plan, settlement hierarchy set out therein, which was found to be sound, logical approach to delivering housing in relation to employment, retail, service and facilities. However, at present, the Council cannot demonstrate a five-year supply of deliverable housing sites as required by the MPPF, currently 4.2, we know it's gone down. This means that for applications involving provision of housing, policies most important for determining applications are deemed out of date. Applications should be considered favourably unless the proposal conflicts with specified MPPF policies or adverse impacts would significantly and demonstrably outweigh the benefits. Yeah? We then see a series of headings. EIA screening, heritage, impacts on landscape, highways including accessibility services and facilities, appropriate assessment impacts on bats, other ecology impacts, fluvial flooding, drainage and surface water flooding, foul drainage, character appearance, residential amenity for proposed development, affordable housing, accessible homes, residential amenity, open space, archaeology, odour, other environmental health matters, climate emergency renewable, other matters, and then the planning balance after conclusions. Yeah?
Yep.
Good. The conclusions are heritage balance, first of all, and then the overall planning balance. And it is this. Harm identified the significance of the Church of All Saints and Wrington Conservation Area, as it was then said, is not outweighed by public benefits, therefore forms a clear reason for refusal, 11D little 1. The proposal would also cause harm to landscape character and appearance. This forms an additional reason for refusal of this application. The first two sentences directed to reason 1, correct?
Correct.
The second sentence directed to reason 2, correct?
Correct.
There is no suggestion in the committee report, the delegated report, which led to the reason for refusal, that the scheme is in an unsustainable village to receive additional housing development of this scale, or that there would be harm to the council's locational strategy, a breach of the plan-led system, or a block on the ability of local people to properly engage with the process. That's right, isn't it? Not one of those observations are in the committee report.
I'll take you to page 13 and page 14 of the committee report, to the section entitled Availability of Public Transport. So that commences, when you have it,
Yep.
that commences by obviously talking about the bus service and referencing the fact that 2 bus services have ceased operating and there's no travel to work service. Then goes on to talk about the additional flexibility inherent in CS32 in regards to service villages, but it does say that that's intended to enable small-scale proposals to come forward, which will enhance sustainability in its wider sense. And then the next paragraph starts, subject to the conditions and legal obligations requested by the Highway Authority. And it then goes on, and it says that the third sentence from the bottom of the paragraph says, notwithstanding this, it is in conflict with policy CS32 and its underlying principles of sustainable development by reason of its scale, which does not reflect the development plan's hierarchical approach to settlements. So I think it's quite clear that that is part of the council's case.
Would you like, please, to go to the matters not in dispute in the Statement of Common Ground, Mr. Reynolds? Section 6.
Yeah, it'll take me a second. My
course.
computer needs to reload, I'm afraid.
That's right. Matters not in dispute.
I have it, yes.
I'm grateful. Matters not in dispute. We have principle.
Yes.
And at paragraph 6.6 it says this: it is agreed that Wrington is a sustainable settlement and that the site is locationally appropriate in terms of policy CS 32, subject to conditions and obligations. Yeah?
I see that, yeah.
Good. That's agreed between the parties. And under the heading Other Matters, if you scroll on to page 19 of the document, 652, the additional further matters do not form part of the reasons for refusal. ... The following matters are not in dispute as a result. 653, access to the services and facilities within Wrington. Yeah?
Yep.
Good. Thank you very much indeed. Let's then, with that all in mind, go to the two reasons which we do have. And they, as we've indicated, are at paragraph 1.7 of the document. It's reason 2 I'm concerned with, and we need to understand what the allegation is.
So just dealing with your first point in respect of the Statement of Common Ground, it is 6.6 says it's agreed that Wrington is a sustainable settlement.
Thank you.
And but that doesn't mean it's necessarily sustainable for this particular development. We just say it is a sustainable settlement. It is a service village where small-scale development is sustainable. So I don't agree that we've said in that regard that we agree that actually Wrington is sustainable for this particular development.
Are you suggesting, Mr. Reynolds, are you suggesting that the inspector should be refusing this planning permission because there is an inadequacy of services within Wrington Village to support the 61 dwellings? Is that the core of your point?
Yes, that's one of our reasons, yes.
One of your what?
One of our reasons.
Not your reasons for refusal,
Well,
is it?
the wording of the reason for refusal could be clearer. I would accept
the wording
that,
for reason is entirely clear, with great respect. Entirely clear, and we're going to come to it in a moment. But are you saying to the inspector that one of the reasons that he should be dismissing this appeal is because there is an inadequacy of services and facilities in Wrington to support 61 additional dwellings?
Yes.
Now that's different from the fact, which we'll have to come to in a moment, that you say there's a particular hierarchy and we want to do things in a particular way. You're making a specific allegation that there is a shortage of services and facilities in this village to support an additional 61 dwellings.
Yes, Wrington is appropriate for small-scale development, given its services and facilities.
That's not the point I'm putting to you. You're making a specific allegation that there's a shortage of services and facilities in this village to support an additional 61 dwellings.
To support this development for 61,
of 61 dwellings, yes. Can you direct me to the reason for refusal that says that?
So it's a reason for refusal to, as I say, I do accept it's not particularly clear, but in the second reason for refusal, and just read out, proposed development by reason of its location within an area of landscape with high sensitivity to change in a prominent location at the entrance to Wrington, along half yard in its scale in excess of that supported by core strategy policy CS32 as part of the hierarchical approach to settlements, would substantially alter an area of attractive open countryside, and it goes on. It's the reference to it being in a scale in excess of that supported by core strategy policy CS32 as part of the hierarchical approach to settlements.
What's that got to do with the adequacy of the services and facilities within the village?
Well, the adequacy of services and facilities within the village the spatial strategy as a whole is predicated on considering each settlement and how sustainable it is in terms of accommodating development.
What has reason 2 got to do with the adequacy of service and facilities in the village?
Well, reason 2 says this development is in excess of a scale which can be supported, given the hierarchical approach.
No, read it again, if you wouldn't mind. Shall we read it together? The proposed development, by reason of its location, nothing to do with services and facilities, by reason of its location, within an area of landscape with high sensitivity to change, nothing to do with services and facilities. Okay? In a prominent location, nothing to do with services and facilities, at the entrance to Wrington along Half Yard, and in a scale in excess of that supported by the core strategy policy CS32 as part of the hierarchical approach to settlements, does what? Would substantially alter an area of attractive open countryside to an urbanized area prominent from certain localized views. So the harm that that sentence identifies, and it's been debated by others, is what it does to the landscape. Yes?
I think it could be more clearly worded,
No.
but it's the
Just
point.
accept,
It's the point
please.
between the two. Well, I don't accept it, Mr. Ball. It's the point between the two commas where reference is specifically drawn to core strategy policy CS32 and the hierarchical approach to settlements. There would be no need to reference the hierarchical approach to settlements if we were just saying it was harmful by reason of scale and would substantially alter an area of attractive open countryside.
Well,
I
yes.
accept it probably should have been more clearly worded. What I would say is it's obviously formed part of the council's statement of case. It's in the proof of evidence.
Well,
your own side have made references to it.
I raised this at the CMC and warned the council this point was coming because it seemed to us the statement of case had strayed from the reason for refusal. You've now developed it in your proof, and you've developed it through my learned friend as well, and that's my objection. Let's go back to the reason for refusal. The allegation is altering what's said to be attractive open countryside. Now, there is, of course, a very sensible reason for putting in the middle part of the sentence of CS30, the reference to CS32, and that's because I, on behalf of the appellant, could easily have turned to an authority and said, well, hang on, you're accepting development in policy of this scale, and therefore you can't really complain when it turns out that there's a landscape impact as a result of it. Yeah?
Well, we don't say that's what CS32 says.
What the first sentence of paragraph, reason for refusal 2, does not deal with is whether there are enough shops, enough schools, places, enough doctors' surgeries, enough pubs to go to, or enough buses to get onto, anything of that nature, does it?
Well, as I said, as I referred, page 14 of the delegated report, the paragraph that starts subject to the conditions, the final sentence of that, to my mind, makes it clear that's part of the council's case.
And
I appreciate it may not have translated as clearly as it perhaps should have done into the reason for refusal, but it was part of the council's case at the point it was determined.
Do you want to turn over the page for reason for refusal 2? Because the allegation goes on, it would be out of keeping with the overall character of the village and landscape setting. Again, that's got nothing to do with services and facilities. Correct?
It's principally, yes, principally.
Thank you. The proposal is therefore contrary to those policies.
Yes.
Thank you very much indeed. Now, that reason for refusal does not allege that the site, that the settlement of Wrington is unsuitable in terms of its facilities to receive an additional 61 dwellings, does it?
Well, it says that it's contrary to policy CS32.
Yeah.
And part of CS32
Well,
is around limiting the scale of development, which in itself is driven by the need to ensure that sustainable levels of growth take place and not excessively large developments. So, not directly, but I would say in a roundabout way.
Well, you've identified for us bullet 1 and bullet 4 as being breached. There's no allegation in reason 2 that it's because of services that the scheme must be turned down. Is it?
Not in the specific wording in reason for refusal 2,
Thank
but
you.
the committee or the delegated report does obviously refer to the conflict with CS32.
Thank you. Nor does it allege a harm in a broader planning sense by excluding local people from engaging the plan-making process.
Well, it doesn't, but that the whole purpose of the final sentence within CS32 around the mechanism by which large-scale developments should come forward, if they do come forward, through the local plan making process, is, it's intended by definition to ensure, therefore, that people aren't left out of the process.
Yeah. But that's not what the reason for refusal is about, is it?
The reason for refusal is about that insofar as that this development's contrary to CS32, which requires, if a larger scale development is to come forward, then it has to come forward through the plan making process.
So it's approaching 11. I'm going to move on to related but a different aspect. Would you like to take your coffee break now?
Yes, if that's a suitable pause in proceedings. What time is it? It's 10 to. If we take a break till 10 past, obviously your mid-cross examination, so if you can ensure that you stay in your witness bubble, please. Thank you. Okay, we're adjourned now until 10 past. Thank you. needs to be here. Yeah. Okay. Yeah, can we continue with the cross-examination, please, Mr. Boyle?
So, thank you very much. Mr. Reynolds, back to your paragraph 3.1, please. The policies you say in play in your issue 1 are CS13, CS14, and CS32. Yeah?
Yes.
And one of the questions the inspector will have to ask himself, therefore, is whether and to what extent these are up-to-date policies in the context of paragraph 11D of the MPPF.
Yes.
Good. And let's just take up the core strategy and understand how these are structured. It's CD A1, A.1, we find the policies. You got that?
Sorry. Okay, I'm looking at the core strategy in the site and allocation plan in a slightly different way. If you give me the page reference, then I'll...
Page 65 is where we find CS13.
65, thank you. Okay, I have it, yeah.
Got it? Good. Now, it says, CS13, a deliverable supply of land, 20,985 for the planned period. Appropriate level of new homes will be reviewed by 2018. And it's supported by text that sets out the history of that figure. You see that?
Yes.
Now, I'm taking it that you're familiar with the, as it were, the backstory of CS13 and how we got to the figure within it. Do I need to rehearse that with you, or is it something that is well known to you?
Yes, I know, I understand the backstory to it, yeah.
You do, good. Well, hopefully we can take it relatively swiftly in that case. But let's just see the structure. So CS13 gives the overall figure.
Yep.
CS14 gives the distribution of that figure,
Yes.
and including reference to service villages and settlement boundaries.
Yes.
Yeah, and obviously that distribution informed by the figure CS13 from which it's derived. And then for our purposes, service villages is the policy CS32.
Yes.
Yeah, so we see that sequence starting off with the core figure of CS13, distributed across the district, and then specifically for service villages, a particular policy, 7 criteria, and the caveat at the end with the 25 to come through local plans or neighbourhood plans.
Yes.
Yes, good. Right. The background to it, we can see at CS13 under the heading background, there was a plan in April 2012, but it was challenged. On the housing numbers had to go back. It was reconsidered by an examining inspector. There was at the time the strategic housing market assessment approach as opposed to the standard methodology approach, and that got caught up with the West of England plan, which was then at that stage rumbling, such that if you look at 38181, until the work was completed, the council cannot move forward with a full objective assessment of housing need as required by the MPPF. 3183, the expectation by early 2017, the council will have a fully MPPF compliant assessment of its need, with the West of England plan having been agreed. Yeah.
Yep.
If for any reason that plan wasn't finalised, the council will move ahead, review of the document and over the page. In either case, the review will be completed by the end of 2018, with the replacement of this policy being adopted by that time. Yeah?
Yes.
And again, I hope we don't need to go off to the local plan inspector's report for this. He found that an acceptable approach given the circumstances at the time.
Yes.
Yeah. Now, we know, of course, what actually then happened was an even less happy story. The West of England plan hit the buffers. It didn't ever give the authority a figure. There wasn't a review. There isn't now. 2018 has now passed. We are in 2022. There's an emerging local plan which is working on a different basis, and at the moment is being given, I think, very limited weight we've agreed to give it, given the timescale. Yeah?
Yes.
In addition to that, statement of common ground, do you have that still to hand?
I will load it back up. I have it, yep.
Got it? It's paragraph 6.7, matters not in dispute.
Yeah, I have it, 6.7.
Got it? So we can record for the inspector, one, the CS13 adopted figure never was based on an MPPF compliant assessment, point one, yeah. Two, it was meant to be reviewed by reference to other documents that never arrived. Three, in any event, it was going to be reviewed in an MPPF compliant way by 2018, but that hasn't happened, yeah.
Yes.
And four, in any event, look at paragraph 6.7, national policy having changed, and the plan being more than 5 years old, you would now look to housing requirement based on the standard method.
Correct.
And we can see the standard method figure per annum at 1392 is materially higher than the adopted figure per annum of 1,049.
Correct.
Yeah. And so we can agree for all of those reasons, and any of them indeed, that the figure in policy CS13 is an out-of-date figure, it's a non-MPPF compliant figure.
Yes.
Yeah, good. That's very helpful. And let's see how then that sounds through the policies, as it were, in terms of what other inspectors have said on the matter. Can we go, please, to the Moore Road decision, which is CD J.20. Do you have that?
I have it, yeah.
I'm grateful. CDJ.20. And do you see at page 3, there's bullet points at the top, one of which is the extent to which proposed development with consistent development plan of the area and weight to be given to relevant development plan policies.
Sorry, which paragraph? I'm at the top of the page.
Tail end of paragraph 9, but it starts on the previous page. So it's the bullet points on page 3.
Okay, yeah, I have the bullet points.
Fourth bullet, these are the inspector's main issues. Do you see?
Yes.
And then under the heading Planning Framework, paragraph 14, whether development plan is considered up to date depends on consistency with the framework, ... Situations, development plan policies are most important depending are out of date, which includes circumstances can't demonstrate a 5 land supply, etc. Paragraph 11D makes it plain that. Yeah.
Yeah.
And if you go on to his fourth issue, it starts on page 13. Do you have that?
Yes.
Main issue 4, consistent development plan, etc. And paragraph 67. In addition to the reasons, policies refer to the reasons for refusal, the appellant considers other policies, the basket of most important, policies CS13, CS14, dealing with respect with scale of new housing and distribution, CS32. Now, we don't need to get on with DM8 for our purposes, but CS32, CS13, and CS14, and you see what he says about that in terms of paragraph 68. Yeah. Common ground, just as you and I have reached common ground, that the adopted core strategy does not include a framework compliant assessment of local housing need. Yep?
Yep.
We agree that. To my mind, this means that policy CS13 is clearly out of date, as is CS14, which simply seeks to distribute this out-of-date housing figure having regard to settlement boundaries, which self-evidently also have to be seen as out of date. As policy CS32 also makes reference to settlement boundaries current at the time of adoption of the core strategy, I consider that too has to be considered out of date.
I
Yeah?
see.
Yeah. Now, there's a distinction for this case because that was actually concerning an allocated site, so he didn't consider that those were necessarily, therefore, the most important policies. But in terms of their out-of-dateness, up-to-dateness, you can see the sequence. The numbers in CS13 are out of date. The distribution, therefore, in CS14 is out of date. The settlement boundaries associated with that are out of date, and CS32, as a consequence, is out of date as well. Yeah?
That element of it, yes.
Yeah, thank you very much. Good. Thank you. That's the Moore Road decision. There's also useful in this context the Farley Farm decision, which is more recent. Do you have that?
It's not a core document, is it?
No, it's not. It came in too late to be as part of the core docs.
Yeah, I have it somewhere there.
But we have it separately.
I have it, yeah.
Got it? Grateful. You have it there?
Yes.
Thank you very much. And for this, we go first of all to the heading Housing Land Supply, paragraph 45. Policy CS13 sets out minimum supply as 20,985, and then reference to the 5-year-old point, and so we now look at the standard method, and the authority doesn't rely upon any review to avoid that.
Yes.
I'm not at this point going to deal with the 5-year land supply issue. I want to move on to the section called Other Material Considerations.
Which para?
It starts at paragraph 91 on page 18.
91. Okay, I have it.
Got it? 93, I consider firstly the provision of policy CS32 relating to development service villages. The context for these policies provided by CS13, identifying the housing requirement figure, and CS14 setting out the distribution hierarchy, exactly as you and I have just agreed.
Yes.
Yeah? These policies are closely connected, with the distribution numbers in policy CS14 being framed around the total requirement figure. The requirement figure set as a minimum allowing higher delivery. However, at the time of the adoption, the examining inspector noted the figure was not based on a full objective assessment of need. They reasoned that with a commitment to review by 2018 embedded in the policy, this could be overcome. At the time, this review was envisaged taking place as part of the wider housing market assessment, which the Council subsequently withdrew. To date, this review has not happened. That remains the case, as we've just agreed.
Yes.
Yeah. I'm aware CS13 figure requirements have been treated as a minimum, reference to the SAP heading another 800 dwellings. Then reading on, nonetheless, the requirement figure in CS13 is the building block on which the spatial strategy for delivering housing has been based, with clear implications for the level of growth envisaged. Do you see that?
Yes.
As the housing requirement figure in CS13 is out of date, consideration must be given whether the spatial strategy and its supporting policies, including policies CS14, CS31, and, for our purposes, CS32, are soundly based. Policy CS14 does not impose a cap on the number of dwellings that can be provided at each level of settlement hierarchy. Nevertheless, the approach to the development of the hierarchy has been set to scale thresholds to ensure that this regards, and I can read on CS32, provide allowance for development outside settlement boundaries, towns, and villages. However, the fact that anything above ... 25 dwellings respectively must be brought forward through local or neighbourhood plan has constrained the degree to which delivery can be brought forward outside the site allocation process. Therefore, whilst the provision of housing against need has improved, the fact remains that with these policies in place, supply has remained well below need. Do you see that?
Yes.
And then paragraph 97, middle of the paragraph, strict application of CS14, CS32 is restricting development to the extent the Council is unable to meet the requirement to provide a 5-year housing land supply. ... The weight placed on conflict with CS32 must be reduced. Yeah?
Yes.
Thank you very much indeed. So again, same point, you have a sequence going CS13 to CS14 to CS32. The origin figures are out of date, the distribution is therefore out of date, and the restrictions under CS32 are out of date. Yep?
Yes.
Good. Then last in this little trawl, because we'll look at other policies, other decisions for other reasons, but this little trawl, can you go to the Cox's Green decision? which I think is CDJ.23, but again, you may have it elsewhere.
No, you're right. I have it.
Cox's Green is in Wrington, of course. We're familiar with the site.
Yes.
Thank you. And here I want you to pick up, please, under the heading Reasons on page 2.
Yep.
Council is unable to demonstrate a 5-year land supply. We'll come back to that point. And so hence in those days it was paragraph 49. The settlement boundaries for Wrington and other villages which have been carried forward from a replacement local plan adopted in 2007 were established in the context of a housing requirement 2011 only and are not the product of a full objective assessment of housing needs as required by paragraph 47 of the framework. The Council and Appellant agree these boundaries are time expired and are not up to date. And then paragraph 13, either of these circumstances is sufficient to engage the second part of paragraph as it was then paragraph 14 of the MPPF. So 2 points grappled with in that paragraph. One, 5-year land supply, but secondly, that the settlement boundaries themselves, being derived from something which was not a full and objective assessment of housing needs, are themselves out of date. Yeah?
Yes.
And those are separate points, as we see from paragraph 100. Can you go to that, please? Paragraph 100.
I have it.
The settlement boundaries are out of, middle of the paragraph.
Starting, however.
Yeah. The settlement boundaries are out of date and in view of the 5-year housing land supply and uncertainties whether it might be remedied through the I give the conflict limited weight. Yeah? Now that point about settlement boundaries being dependent on out-of-date assessments of development needs being rendered out of date and accorded reduced weight as a result, that accords, doesn't it, with the judgment of the Supreme Court in Hopkins Holmes. You'll be familiar.
Yes.
Yeah, so I hope we don't have to go to it. It's in the core docs. It's paragraph 63, Lord Conworth, where settlement boundaries are predicated on assessment of out-of-date assessment of housing development needs, they can be given reduced weight accordingly.
Yes.
And that is a route to being out of date quite separate and independent of the calculation of 5-year land supply. It's to do with the spatial strategy itself.
Correct.
Yeah? So we can record, therefore, for the inspector, can't we, agreement between us that the spatial strategy represented by CS13 and its dependent policies CS14 and CS32 is in its own terms out of date.
Yes, we can record that it's out of date. Or,
Thank you.
Yeah.
Now, in addition to that, we have the question of the 5-year land supply and the operation of paragraph 11D via footnote 8. Yeah?
yes.
And you, by all means, turn that up from the MPPF if you want to, but I'm sure you're very familiar. Footnote 8 is a deeming provision. Yes?
Sorry, I have it. I was just finding it. Can you
Certainly.
repeat? Sorry.
Footnote 8 is a deeming provision,
Yes.
and it deems the creates most important policies for the application out of date. In the circumstances we have here, the Council cannot demonstrate a 5-year land supply.
Yes.
And in that, it then triggers 11D. There are questions of weight, but you are not, on behalf of the Council, suggesting that the shortfall in land supply enables you to run what we call the Gladman-style case, where it's only just a little bit under, and we're going to sort it out in a few moments, and all is fine, so don't give too much reduced weight. That's not the case you make, is it?
Well, are you asking me whether or not 11D is applicable, or are you asking me to comment on the weight of the individual housing
No,
policies?
I'll come
We'll
to
on that.
individual policies
Okay.
in due course, but you're not making the Gladman-style case by reference to the amount of shortfall. The parties are agreed it's a significant
No, I'm
shortfall.
not making that case.
I'm grateful. Thank you very much indeed. And so 11D then, and we know it's in 2 parts. We're going to have to look at paragraph 202 in a moment, but 11D is engaged by footnote 8, as well as the fact, as we've just agreed, the spatial strategy is out of date in its own terms. Yeah?
Correct.
Good. Now, With that in mind, can we go back to the Cox's Green decision?
Yeah, I have it.
And I'm going to turn attention to what you say about the 25 dwelling reference. Okay?
Okay.
So you may still have policy CS32 to hand.
I can get it.
Got it?
Sorry. Yeah, I have it.
Okay. CS32, 7 bullet points, and then the proviso at the end.
Yes.
Yep. Of the 7 bullet points you've identified, you consider breach of 1 and 4, but by reference to heritage and landscape, which I don't rehearse with you for reasons I'm
Yes.
sure you well understand. I'm focusing on the proviso at the end. Sites outside settlement boundaries in excess of about 25 dwellings must be brought forward as allocations through local plans or neighbourhood plans. Yeah.
Yes.
Now, we know in this authority the local plan process has essentially stopped for this core strategy. There's a whole new local plan coming forward on a different basis. Yeah.
Correct, yeah.
So it's not going to happen through that. And we know for this settlement, although there was, I think, talk at one point of a set neighbourhood plan, that hasn't been carried forward. There's nothing before the inspector that Wrington's going to have a neighbourhood plan.
Well, not that I'm aware of.
No. So thank you very much. In terms of the figure there, the 25 dwellings coming forward as an allocation, can you take up the Cox's Green decision again?
Yeah.
J23. It's this time on page 3. Paragraph 18. The use of the words within or adjoining settlement boundaries in the first part of Policy 32 clearly provides for development outside of existing village envelope. As the appeal immediately abuts settlement boundary Wrington, the proposal complies with this part of the policy. I heard you talk about the paddock, but I don't think there's any dispute between the parties that the site abuts the village, the adopted settlement boundary of policy CS, adopted settlement boundary of Wrington. Having considered the arguments put to me, I find that policy CS32 does not set any ceiling as to the level of housing development acceptable either within or adjacent to settlement boundaries. The reference to about 25 dwellings relates to proposals outside settlement boundaries and stipulates only that such proposals should be brought forward as allocations through local or neighbourhood plans. The site is not allocated a neighbourhood plan, and the proposal conflicts with this procedural requirement. Yeah?
Yep.
The inspector there recognises that the policy itself doesn't cap at a given village, either in total, how much may come forward on a number of sites, or how large any given site may be, albeit it gives a process that must be followed if it's in excess of about 25 dwellings. Yeah?
I wouldn't accept that. I mean, the policy CS14 makes clear that it's small-scale developments. We've been through the inspector's report as well into the remitted policies on the core strategy, and it's quite clear in those terms that it was not envisaged. I certainly don't accept the argument that this policy allows for any development of any size in theory to come forward through a neighbourhood plan or local plan.
Small scale is not defined, correct? In CS14?
Not in terms, but having said that, I do think that the references to 25 dwellings are clearly intended to be an indicator of what might be considered small scale.
By way of process, as this inspector has recognised, that there is a procedural requirement that if you're larger than about 25, then you would need to come forward as an allocation either through the neighbourhood plan or the local plan.
Well, it's partly procedural, I accept, but I would also refer to the Rectory Farm and the Farley Fields decisions, which the inspectors treat it as a maximum, 25. They don't take quite the same view as the inspector in the Cox's Green appeal.
I'm going to come to those in a second, but let's just recognise this. This inspector recorded as a procedural requirement, first point.
Yes.
Yeah. It doesn't limit, I say, either the total to come forward in a village on a range of sites, nor on a specific site, but if you're in excess of 25, about 25, there's a procedural requirement for the process. And then this, you see, as the settlement boundaries are themselves agreed to
So
be...
which paragraph are we on,
I'm
Mr.
so
Boyle?
sorry, where we were, paragraph 19.
19, okay.
As the settlement boundaries are themselves agreed to be out of date, only moderate weight should be given to this requirement of the policy. That's his conclusion. And that's on the basis, as we have agreed, still the applicable situation here, settlement boundaries are out of date. Yeah?
Yep.
Moderate weight to this part of the policy. And then if we read on, forgive me. I hope you can find, it's called Conclusions on paragraph 14.
So read on. Do you mean we go backwards?
No, go,
sorry.
go forward in the document to page...
You mean MPPF 14?
Page 13.
Right. Okay.
Conclusions on paragraph 14, starts at paragraph 47. I don't know if someone could ask kindly that those people... Thank you very much. Mr. Reynolds, are you there? It starts at paragraph 74. I want to draw your attention, please, to 79.
Sorry, paragraph 79? We were going to 73.
Paragraph 74 on page 13 is where the passage starts.
Right, okay.
But I want to take your eye to paragraph 79 on page 14.
Okay.
Got it? There is conflict with the procedural requirement under Policy 32, but the only harm that might flow from that conflict is the expectation that local community might have that any decisions about the capacity of the village to accommodate more housing should be taken through the development plan process. That echoes, doesn't it, in fact, one of the points you've introduced into your issue 1.
Well, I certainly don't accept in this case that the only harm that would result would be a breach of that procedural requirement as this particular inspector identifies.
The point about the expectation of the local community,
yes.
that echoes one of the points you've introduced into your issue 1, yes? And then he says this: such harm is, however, likely to occur in situations where the development plan has not been successful in ensuring a 5-year land supply. And that, of course, is right, isn't it? Because when there isn't a 5-year land supply, we're in a situation of paragraph 11D by operation of footnote 8.
Yes.
Yeah? And where the framework stipulates that relevant policies for supply of housing should not be regarded as being up to date. And as we've just agreed, for 2 reasons, the policies are not up to date, both 5-year land supply and also the spatial strategy in terms.
Yes.
Yeah? Only limited weight, therefore, can be given to that conflict with policy CS 32. And that's that conflict point is the in excess of 25 not coming through a neighbourhood plan.
That's how I read it.
So limited weight. Thank you very much. And then just to complete the point on this decision, paragraph 100. Here he brings it together, the 2 points. Settlement boundaries are out of date. In view of the shortfall of 5 land supply and uncertainty, the adoption of the plan, I give that conflict limited weight. Yeah?
Have that, yeah.
Good. I'm grateful. Thank you very much indeed. Now, I said we'd... we'd return to the other decisions as well. Can I go to Rectory Farm this time? CDJ 22, I think it is.
I have it, yep.
Do you have that? And the first point I'm going to pick up is at paragraph 43. Where the inspector notes, as I was suggesting to you a moment ago, that there's nothing in CS32 that would prevent, subject to appropriate compliance with the bullets therein, 4 schemes of 25 coming forward over time. And as he got a quote there, there's no numerical target to aim for or be constrained by in policy 32 as to the number of 25 dwelling schemes that might be granted permission, and the policy applies to individual applications such that there could be a series of applications coming forward. So settlement-wide, there's no cap. The inquiry, Mr. Underhay acknowledged there was need for 100 dwellings somewhere in Yat, and the principle one scheme, single scheme might cause less harm and deliver more cumulative benefits than 4 scattered ones. Although the correct approach would be to pursue the proposal through the local plan process, that's the caption, the proviso
Yes.
of 25, Mr. Hay agreed that if there's no 5-year housing land supply, which is the situation here, yes,
Yes?
there may be more scope in terms of numbers to be permitted under a scheme pursuant to CS32. Do you see that?
Yes.
And then if you read on to paragraph 43, drawing the threads together, it's clear to me the previous
Hang on.
says,
So,
Sorry,
can I,
sorry, that
can
was
I,
paragraph
can I
43.
interrupt? Can I just double check who Mr. Underhay was? Presumably he was the council's witness. Is that right?
let's go to the,
He was, yeah.
He was?
He was the council's
Okay.
planning witness.
Okay, thank you.
yes, principal planning officer,
Okay, thank you.
called
Sorry
by
to
the
interrupt.
council. Not at all, sir. Paragraph 46, drawing the threads together. Are you there, Mr.
I'm there,
Reynolds?
yeah.
Yeah. Drawing threads. It's clear the proposal up to 100 dwellings would deliver a scale development that's in conflict with the spatial strategy development plan, which permits sites up to around 25 adjoining settlement edges, service villages. The proposal is therefore contrary to policies CS14, CS32, the core strategy. However, there's no 5-year land supply in this case, and indeed significant shortfall, and therefore CS14 and 32 cannot be given full weight. Rather, these policies can only be afforded limited weight. Do you see that?
I see it.
I'm grateful. And then we need to go to the conclusions. Planning balance
Which paragraph?
starts at 140.
I have paragraph 140.
140. Starts with the same observations. 100 is in excess of 25, therefore contrary to 14 and CS32. However, there's no 5-year housing land supply in this case, indeed significant shortfall. Policies CS14 and CS32 are most important policies, but they cannot be given full weight. These policies are out of date and can only be afforded limited weight. From the evidence before me, I cannot agree with the Council's suggestion that significant or indeed or moderate weight might be given to these policies. Yeah?
Yep.
So again, in the circumstances that we have before our inspector as agreed, limited weight to breach of the 25 limit by reference to the procedure of neighbourhood plan, local plan. Yeah?
Well, that's, I haven't agreed that, but that's what the Cox's Green decision said, yeah.
Well, we're now figuring this is Rectory Farm,
Yeah, and the
the Rectory Farm decision. Thank you very much. Thank you. And we can conclude with the similar observations in the Farley Farm decision, the most recent one. Do you have that?
I will find it.
And for speed, I'll just go straight to the conclusions.
Which para?
It starts at 143.
Okay, yep.
Got it? and it's paragraph 144, reference to plan-led system, but also means community requirements must be up to date. And then 145, I found the weight that can be given to the conflict with CS32 ... is greatly reduced by the growing needs of North Somerset not being met. As a result, I give limited weight to the harm arising from this conflict.
I see.
You see that? I'm grateful. Now, I say, I'm not going to get in with you at this stage the debate about bullet points 1, bullet point 4, based on other people's expert evidence. But in terms of the pure point of if it's more than 25, it should come forward through the neighbourhood plan or local plan process, we can see, can't we, consistently that inspectors have first of all recognised that the policy is out of date, both in its own terms and for 5-year land supply reasons, yes?
Yes.
And secondly, accordingly, they have given any limited weight to the fact that there's a breach of the 25 limit on that basis.
They have.
Yeah. And you're aware, obviously, of the general duty and importance of consistency in decision-making on behalf of the Secretary of State.
Yes.
And these are all recent decisions on policy CS32 concerning service villages, including in one case our village itself.
Yes.
Yeah, I'm grateful. Thank you very much indeed. Thank you. With that in mind, then, can I go back to your proof, please?
I have it.
Thank you very much. I want to go, please, first of all, to page 25, 537. Under the heading 5-year land supply.
Yes.
We've got CS13, CS14, CS32 there cited. We've agreed now that not only are they out of date by reference to footnote 8, because of the land supply situation, they're also out of date in their own terms because they don't deliver an up-to-date assessment of housing need.
Yes.
Yes? And therefore, rather than them closely aligning with the MPPF, they are in breach of the MPPF.
In that respect, yes.
Thank you very much. Okay. Then, when we turn to section 6, planning balance, you start with the benefits first. I'll come back to those in a moment. But let's go to the harms. .10.
Yep.
Because bullet 1 and bullet 2, sorry, it could be bullet 1 and bullet 4 of paragraph of policy CS32 are dealt with through the heritage and the landscape points. Breach of CS32 for those reasons are your issue 2 and your issue 3.
That's correct, yes.
Issue 1 is a size in excess of the 25, which should be brought through, you say, by the neighbourhood, through the neighbourhood plan process, allowing people to be involved, etc. You've given that significant weight. What we can see is consistently inspectors have given limited weight to that point.
In the appeal decisions you've taken me to, yes.
Thank you very much. Limited weight. Thank you. Now, let's then turn to paragraph 611 and 612. There I find the heading, not the heading, the conclusion, substantial weight.
Yes.
Yeah. And I just want to get your help with the calibration of this, please. Substantial weight, I'm deducing in your mind, is more than significant.
Yes.
So it's a weight greater than significant.
Yes.
Yeah. Let me help you, see if you can help with the calibration. Turn back a page to the benefits.
I have it, yep.
6.1, the benefits for the delivery of housing is given significant weight in your mind.
Yes.
And 6.2, for affordable housing, is given significant weight in your mind. So there's, if you want to calibrate the matter, as far as you're concerned, the provision of housing and the provision of affordable housing in the context of an authority which is failing to deliver a 5-year land supply, and we have the information on affordable housing, has a trailing housing, affordable housing provision against an increasing need. Yeah?
Well,
Those, you say, are accorded significant weight.
I say, yeah, I'm talking about this specific appeal proposal. I'm not speaking
Yes.
in general terms about North Somerset's housing position. I say in this particular appeal, for all of the reasons outlined, that's the conclusion I've reached, yeah.
That I understand. I'm only talking about this particular appeal as well, but we set it in the context, don't we? There's 61 houses, up to 61 houses being delivered in the context of an MPPF implication to boost significantly the supply of housing, and a particular North Somerset issue that there isn't a 5-year land supply here. Yeah?
Yeah, and I attribute weight to those points, but as I said earlier, I also temper that weight by the nature of the proposal and its location, etc.
Well, but we know there isn't a location objection to this scheme. It's in the Statement of Common Ground.
The Statement of Common Ground says that it is a sustainable settlement. It doesn't say it's sustainable for any level of development.
And the site is locationally appropriate. Remember that?
Well, insofar as that it abuts the housing boundary, yes. So, yes, it says that, but it doesn't say that this is...
So we've got the provision of housing, up to 61 units. We've got the provision of 30% affordable housing. Those are both set, of course, by the inspector in the context of national policy seeking to boost housing delivery and the local situation of the absence of 5-year land supply. Also, affordable housing need going progressively worse. Yeah?
Yes.
And those, in your mind, get significant weight. No higher than that, just significant weight. Okay? I'm just holding for the calibration purposes, because everyone will come to a slightly different view. I want to understand how you've calibrated.
Well, yeah, they do, but that's only part of the picture. I mean, the weight that I give to the housing benefits depends on where those houses are and the benefits that the scheme will deliver. So I agree, and I say that, yes, significant weight in this particular case to the benefits of housing. Now, I might say it might be higher in a more sustainable location.
Oh, right.
But in this location, I say that it is significant because for the reasons I've outlined, that there are reducing facilities, limited bus service, etc. within Wrington itself. I don't consider it to be a sustainable location for a development of this size.
Well, that's a very interesting point, because that would indicate that if you had, say, 25, which would be compliant with policy CS32, you might get substantial weight for 25, but only significant weight for 60. Doesn't seem right, does it?
Well, there's no scheme before us for 25.
No. Come on, you can run with the principle.
Well,
if it was 25 or 24, it would be numerically, you say, appropriate for a service village under CS32.
It would comply with that element of
Yeah,
CS32 potentially, but
Thank
it
you,
might. But it's a moot point in my view in respect of Wrington, because there are very few sites in Wrington that can come forward, and there are no other sites coming forward delivering 25 houses. There's this site and 3 others outlined in the SHLA, 2 of which are in the Greenbelt, and there's the floodplain to the south. So there's very limited opportunities for Wrington to expand. So I don't think if this scheme was dismissed that there will necessarily be other schemes coming forward of 25 houses in and around Wrington.
It's not the point I'm on, Mr. Runs. I'm just testing your proposition. Housing provided at Wrington, for some reason, gets less weight the more of it there is.
No, I don't say that. You said that I might attribute substantial weight to less. I don't say that I would.
All right. In any event, it's helpful, because if the inspector, of course, finds, as I'm going to suggest to him, that these points about the absence of sustainability in Wrington is A, not part of the council's proper case, and B, not made out in any event, because the site is a sustainable location in a sustainable settlement, then he might attribute a higher weight than your significant. But let's just stick with what you've got, okay? You've pegged it at significant for the provision of housing and the provision of affordable housing.
Yes.
That's on the one side. Now, let's see how the calibration works the other way. You've given substantial weight, that's a category higher than significant, substantial weight in your 611 and 612 to the heritage and to the landscape point.
Correct.
Yeah. So more weighty than the delivery of housing and affordable housing comes the concept of moderate impact on a, quote, non-valued landscape for the purpose of paragraph 174A of the MPPF. That's your professional judgment, is it?
That's not. Mr. Etchell's evidence was that it was moderate to high at year one. So when the scheme is built, then that will be. But you can't jump straight to when the scheme's 15 years old. It will be 15 years will need to pass before you reach that point. So the harm will be greater when the scheme is first implemented, as is the case with any scheme.
Yes.
And then he says it will still remain moderate adverse after 15 years.
Exactly. So that's why I put the point to you, because, of course, housing, we hope, is a long-term exercise. The harm arises year one, and because of the nature of the proposal, it declines in its degree to the point, even on Mr. Etchell's basis, of reaching moderate adverse at year 15. Yeah? Now, are you telling me that your substantial weight doesn't apply to the moderate adverse, it only applies to the year one situation?
No, because they're different terms.
Fine. So in that case, let's look at the year 15 situation. You say substantial adverse weight arises from the moderate adverse impact on the site and its immediate environs in a non-paragraph 174A valued landscape. Is that right?
No, because it's an artificial distinction to make. I can't give weight to it, ignoring the first 15 years and then saying the weight is out. The combined, you have to look at it in combination. There are short-term effects, and then, yes, over time, landscaping will, as Mr. Etchells indicates, reduce the effect, but it remains at moderate adverse after 15 years. So I have to consider it in the round.
Yeah, I understand this entirely, Mr. Reynolds, which is why I'm asking the question. You start at substantial for, as I think it's moderate high is his reading, isn't it?
Well, he says moderate to high is what is the term
well,
that's
actually,
used.
he clarified that it meant moderate high. It's somewhere between moderate and high is what he told us. So moderate high, you give substantial weight. Declines over time to moderate, you're still giving it substantial weight.
No, I'm giving one weight overall.
All right.
I'm not giving a weight at year one and then a weight at year 15.
In any event, it's in respect of a non-valued landscape for paragraphs of 174A purposes, isn't it?
It's agreed it's a non-valued landscape, yes.
Yeah. And so when we talk about the calibration of your judgment of harm against calibration of benefit, the provision of housing in the context that we've set it is less weighty than the impact recorded on a non-valued landscape.
In this case, it is outweighed, yes, by the harm.
Yeah. Now, the policy CS32 admits of the principle that development can step outside settlement boundaries into the countryside.
Yes.
It might do up to 24 absent a neighbourhood plan allocation, consistent with the wording of the policy itself.
Correct.
It might do in excess of 25 with a neighbourhood plan allocation consistent with the policy itself.
Yes, providing the bullet points are
Yes.
satisfied as well, yes.
And with that will inevitably come landscape impact on the site and its immediate surroundings. That's inescapable.
The same is true of any development, yes.
Exactly.
There will be some
Well,
impact.
But this is a policy-supported impact, isn't it? Because it's inevitable there's going to be landscape impact on the site and surroundings.
Yes, but I don't think Mr. Etchell's case is that pure just simply because there's housing means in principle nothing could ever happen, because it will change the context of the site in terms of its landscape.
I've left Mr. Etchells behind now, and I'm on the planning witness and the weight to be given to that inevitable impact. Yes? So policy CS32 admits of the inevitability of landscape impact. We agree that.
Yes.
Yes, good. In terms of the hierarchy for planning consideration of landscape, you understand that there's it's described as international, but certainly national, regional, and other local designations. Yeah?
Correct, yes.
I can take you to the paragraph if you need to in the MPPF. Do you want to go to it? Paragraph 74, and then...
Let's go to it just to refresh my memory.
...174, and then the reference to the hierarchy is 175. Do you have that?
I do, yeah.
Hierarchy of international, national, and locally designated sites, ... And 174 divides A and B, and A, protecting valued landscapes, and then you see the bit in brackets, in a matter commensurate with their statutory status or identify quality in the development plan. Yeah?
Yeah.
So we have the hierarchy for landscape purposes of designations, which might be national designations like A and B. They might be local designations, such as areas of landscape value, whatever the term may be in any given local plan. They might be non-designated, but recognized as, quotes, valued landscapes for the purpose of paragraph 174A. Yeah?
Yeah.
Or they might be not even that. That's the hierarchy. Yeah?
Yeah, and 174B.
And we are in the bottom of that list. So if we go to paragraph 75, international, national, and locally designated landscapes, we're off the bottom of the scale, aren't we?
Well, we are, but of course 174B applies, that you should
Yes.
recognise the intrinsic character and beauty of the countryside and the wider benefits.
Indeed
etc.
so, and the distinction therefore made between how you treat valued landscapes, which is protecting and enhancing. So you see the distinction there drawn by the authors of the MPPF.
I don't read this saying that you shouldn't protect and enhance countryside locations which are not valued landscapes.
The test in B is to recognise intrinsic. That is to take it into account. If there's harm to it, you take that harm into account. Yeah?
Yeah, recognising the intrinsic character and beauty of the countryside.
Thank you very much. And the protecting and enhancing is applied to valued landscapes, which we're not.
No.
And even there, how you do it is in a manner commensurate with its status. Yeah?
Yeah.
So even amongst the designations, you do it in commensurate with status. And so the inspector gives weight, or you as a planner should give weight, increasing as you go up in status and declining as you go down in status. Yes?
Yes.
Yes. And so here we've got a situation where there's a policy that provides for the stepping outside of out-of-date settlement boundaries, which is going to inevitably bring with it landscape impact as a result. The question then turns to what landscape? This is a landscape off the bottom of the hierarchical scale, isn't it?
Well, yes, you would say it was ordinary countryside. Yes. We say that, yes, we identify between moderate high and moderate adverse impact on that landscape.
To a non-valued landscape.
To a non-valued landscape,
To a landscape
yes.
off the bottom of the scale.
Well, that's your terminology.
No. It's what we've just agreed, isn't it? There's a hierarchy.
Where's the scale? I mean, I understand.
Paragraph
your
175.
point.
The hierarchy.
Yeah.
We're none of those, are we? We're not even a non-designated but valued landscape for 174A purposes. We're a rung below that.
It's a countryside location, so
Yes.
174B.
Exactly. We're a rung below the 174A circumstance, aren't we?
Yes.
Which itself is to be protected in a manner commensurate with the status of those landscapes.
Yeah, but that's a commentary on protected landscapes.
Thank you very much, which we're not. And so I put it to you again. What we've got here is a policy in the development plan. I know we recognise it's out of date. It's a policy in the development plan which admits of stepping outside out-of-date settlement boundaries, which will bring inevitably landscape harm, because that's the way the delivery is constructed. So we turn our minds to what landscape is being harmed, whether it's moderate high or moderate, depending on the year 1, year 15. And we find it's at the bottom of the scale, don't we?
Yes. Yeah.
Right.
Okay. So it's not a designated valued landscape, as we say. But it still falls to be considered against the local plan policies and, of course, the MPPF. It's not necessarily the case that it's not possible to give substantial weight to landscape harm outside of a valued landscape.
Well, that's my calibration point, you see, because you're only giving significant positive weight to the provision of housing and affordable housing in the context of the MPPF 5-year supply and all the rest. And yet you're giving substantial weight as a category above, substantial weight to an inevitable harm that comes to, as a result of that policy, that comes to the lowest level of landscape for our purposes.
I think that's oversimplifying things. You need to consider the individual site and the impacts on the landscape.
Well, that's exactly what you've done, isn't it?
Well, absolutely, yes. Yeah. And that's why we say that in this particular site, there will be significant landscape harm. I don't contend that there may be other sites in other areas which may have less impact, of course. It's a judgment to be reached.
It's the weight I'm on, not the harm. The harm we've got a different witness on. It's the weight I'm on. The calibration of the weight, Mr. Reynolds, is plainly out of kilter, isn't it? To give substantial harm to an inevitable impact on a non-valued landscape.
Well, I don't accept it's an inevitable impact. I accept it's a non-valued landscape. But the terminology used by Mr. Etchell's, moderate high, dropping to moderate reverse, that could still be substantial harm.
There we are. Thank you. Lastly, then, the heritage point. The witness for the authority was very fair and very open, that she agreed with the evidence of the appellant that what we're contemplating here is the lowermost end of the less substantial category of heritage impact.
Correct.
The lowermost end. Now again, there are therefore a whole range of other findings which must be higher than that. There's a range within the less substantial, say from lowermost to low to a bit higher, medium, really quite high, jolly high, nearly substantial. Yeah? You set the dial as you go up. And then, of course, there's substantial, where there is a whole set of other policy tests as a result, and the weight to be given. Yeah?
Yes.
And inevitably, the weight must rise, mustn't it, in terms of the planning balance. The weight must rise to the negative as one progresses up the scale through less than substantial and then eventually into substantial.
Well, that's correct, but there is also a secondary factor at play in that you need to consider the designation of the individual asset, because that will influence the weight.
That much I recognise. But the point I put to you is correct, isn't it?
Yes.
Yes. And yet, at the lowermost end of less than substantial, again, calibrated against your significance, you've given this a substantial weight of impact. Mr. Reynolds, is that right?
That's correct, yes.
Which leads you nowhere to go. If, for example, Dr. Hudson Macaulay were to have turned the dial up, where would you have gone next?
Well, it could have been very substantial.
Very, or great.
Yeah, I mean, there's lots of different terms you might use. The judgment that I'm reaching is in part based having regard to para 199 and 202 of the MPPF,
Yeah.
and I'm
Now,
told that irrespective of whether any potential harm amounts to substantial harm, total loss, or less than substantial harm.
Given that you've
give weight.
looked at it from the other end of the telescope, given that you've given substantial weight to the lowermost end of impact in heritage terms, we looked at paragraph 202, yeah?
Yep.
The provision of housing on your calibration isn't ever going to achieve the outweighing of that substantial weight, is it?
There's two factors. There's the categorization of the weight that you give it, and then there's the weight that actually is afforded depending on the circumstances of the individual factor. So it could be a very high category of harm, but it might not be a huge amount of it, if you take my point. So I don't agree that,
Well, we've got the
that I'm saying, because I say significant weight to the housing in these circumstances for the reasons that I've outlined. But I have to give great weight to the conservation of the Grade 1 listed church, So I'm balancing great weight, and that's irrespective of the fact that it's less than substantial harm. I have to give great weight to that, and then I have to weigh that against the benefits. And the benefits in this case, it's a clear reason for refusal. Substantial harm to the building outweighs it.
Fortunately, it isn't a mathematical or quantitative exercise, as the courts have told us, but let's just bring the matter to an end. The case you put on behalf of the authority is that the provision of housing in the context of the absence of 5-year land supply and a worsening affordable situation does not outweigh the lowermost end of impact to one heritage asset and the inevitable landscape impact on a on a non-valued landscape for MPPF paragraph 174A purposes. That's your case, isn't it?
The case essentially is that the harm to the heritage asset constitutes a clear reason for refusal, which disengages the tilted balance. So in that regard, yes, the harm to the heritage asset forms a clear reason for refusal. That outweighs the weight to the benefit of housing, and all other public benefits, which I've outlined.
Thank you very much. So those are my questions.
Thank you. Something that I was sort of mulling over in my own mind is once you've done just doing the discrete heritage balance, the public benefits balance. Once you've done that, I understand your position, but if a different position, a different outcome were to flow from that, is it conceivable? What's the implication of that? We're still in this sort of binary scenario of doing the following planning balance. Is it a fait accompli at that point if it fails the public benefit, or in your mind could the appeal still go the other way? I'm not sure I expressed that very well, but
I think I know what you mean. If in a case where the heritage harm forms a clear reason for refusal, having regard to all the public benefits of the scheme, it seems very unlikely in those circumstances that you could then reach a conclusion on a 38-6 balance, taking into account any other harms at that point, that it could. So I say the tilted balance is disengaged. If you say the tilted balance, if were to conclude that it's not a clear reason for refusal, then obviously we need to weigh all the other harms and any benefits that are not public benefits, etc.
And I mean, if you've not gone through that in your own mind, but I won't press the point. But what would be the outcome of that if? I mean, I'm putting this hypothetically. And it is just a hypothetical point. Is this, after doing the public benefit balance, can things turn out differently? Is really my point to you in this case.
So I mean, if in the circumstances where a clear reason for refusal is not identified, so then the tilted balance is engaged for the reasons that obviously we've discussed this morning. At that point, then you need to weigh in the landscape harm that we've identified. You also need to take into account the heritage harm, all the benefits of the scheme, and reach balance. We say that in those circumstances, even if the tilted balance is engaged, that those factors clearly and demonstrably outweigh the benefits of the scheme and suggest the appeal should be dismissed.
Okay, thank you. So you think that path leads you to dismissal? Okay.
Yes.
Thank you. All right. Any questions in re-examination, Mr. Wadsley?
Thank you, sir. Sorry, I beg your pardon. 2 or 3, if I may. Can we go back, Mr. Reynolds, please, to taking these in reverse order, because that's just easier from my point of view. Can I go back, please, to where you were being asked about your calibration of harm, particularly in relation to landscape. You'll remember the series of questions about what Mr. Etchells had said about the harm, and then there were suggestions about this accepting for the moment your approach. There were questions on the basis of this, or rather there is development which could comply with CS32. In other words, it could be 25 houses or less, say 24 for the sake of argument, and you would then inevitably have some form of harm, even though it was in accordance with policy CS32. If, on the other hand, that development were to be greater and were to come forward as part of an allocation in a local or neighbourhood plan, assume that for the purposes of my question, you would have the same degree of harm, plainly, but how would that harm have been dealt with? Assume it's a neighbourhood plan allocation, assume or local plan allocation, assume it's being considered in accordance with that plan or those plans being brought forward. What would be the context for considering the harm?
I'm sorry, I'm not sure I follow your question.
All right, then it's my fault. Let me try again. If you are having a site like this brought forward in a local plan or neighbourhood plan, take a local plan because that may be easier. What process will be gone through in considering whether such a site could come forward?
Okay, so if the site were coming forward through a local plan process, then it would come forward potentially as an issues and options stage first, and then a regulation 18 plan, which would be a preferred option stage, and then after that a submission plan. At each of those individual stages, members of the public would be able to engage with the process, and it also would allow the council would be effectively using the SHLA to identify potential sites, and the council would be doing a comparison exercise between the sites to choose the best sites to potentially bring forward through that process, rather than a planning application being lodged, which obviously then needs to be determined, but sort of skips those stages in the process.
So if you have a site that is not brought forward in terms of a planning application, but is brought forward in a local plan or indeed a neighbourhood plan context, what you're telling us is that the process would allow competing or alternative sites to be considered. Have I understood you correctly?
That's correct, yes.
Thank you. The Cox's Green decision, I mean, I think I have two questions on that. Do you know when the Sites and Allocations Plan, the SAP, was brought forward and adopted? Do you know whether it was pre or post Cox's Green?
So it was adopted in July 2016. And I'll have to find
the site allocations, the site allocations plan, not the core strategy.
Apologies.
It doesn't matter if you can't.
Sorry, April 2018.
April 2018. So it postdates Cox's Green.
Yes.
Okay. Could you go to the Cox's Green decision, please? 23.
have it.
I haven't, bear with me.
J23.
No, I've got it. It's just
Oh, I see.
this particular folder is a bit difficult to manoeuvre. You go to paragraph 100, please, because I want to look at the context of the Cox's Green decision. The inspector records there that the proposal complies with the substantive requirements of policy CS32 and the detailed criteria in its 7 bullet points. The only conflict, he says, is with the procedural requirement, what he calls the procedural requirement, in relation to proposals for more than about 25 dwelling on sites outside the settlement boundary. Now, you've discussed with my learned friend the weight that should be attributed to that part of the policy dealing with the 25 limitation, if I can call it that. I don't want to ask you about that. What I want to ask you about is this, quite simply. That proposal substantively complied with policy CS32. What is the position in relation to this proposal?
So, yes, that's different from the appeal proposal, where I say that this is in conflict with bullet points 1 and 4 of CS32.
Okay. Thank you. Dealt with. Would you mind just going briefly to the Farley Fields appeal decision, please? Paragraph 98. Because I think there the inspector was dealing with landscape and related issues and the weight to be given.
Yes.
Did he give any reduction in weight to the landscape policies?
No, he said they were fully consistent with the framework and there should be no reduction in weight to policy CS5, DM10, DM32 and SA5.
Thank you very much. And just dealing with the reasons for refusal cross-examination at the beginning of your cross-examination, could you go please to, I've mislaid my copy yet again, to section 4, please, of the Council's statement of case. It's page 5.
Do you know the core document?
I don't think it's a core document.
Oh, okay, sorry, it's on the page, isn't it?
Please, I haven't traced it. Well, if you've got a paper copy and can give it to me,
Might be quicker,
I'd be very
yeah.
grateful.
Thanks. So which paragraph was it?
Section 4,
Section 4.
4.1, 4.2, specifically 4.2.
Yeah.
What's set out there in relation to the way the Council seeks to put its case, please?
So it's policy CS32 defines Wrington as a service village, sets criteria within which new development at the edge of the village is expected to meet. And then we say the appeal scheme conflicts with policy CS32. And then we say we'll make reference to relevant appeal decisions in respect of residential development at or on the edges of service villages. And then we say specifically the proposal to build up to 61 dwellings exceeds the limit on the scale of speculative development of about 25 dwellings. And we say that it will be demonstrated that sustainability threshold is at the heart of the sustainable development strategy for service villages, and development at the scale proposed is incompatible with the adopted spatial strategy.
Good. Thank you very much. And if, for these purposes, one has to look at an issue like bus services, transport, what do you say about that in relation to sustainability and the appropriateness or otherwise of referring to it?
Well, these are absolutely fundamental questions in determining any spatial hierarchy. The ability of future residents who might live in a settlement or on the edge of a settlement, it's critical, obviously, to consider the degree to which they'll have access to employment opportunities, services and facilities. So it's absolutely at the heart of any plan-making process that I've ever come across.
Thank you very much. Sir, you raised a question with Mr. Reynolds. I don't know if your question might be at least partially answered by paragraph 6.14 of his proof. I hesitate to try and reinterpret anything.
It occurred to me, but shortly after putting the question, but I thought I'd read it in his proof, and sure enough, it's there, but or at least sufficient for my purposes. So I think it was possibly a redundant question. So apologies to prolong your agony.
No, that's fine.
No, sir. Well, thank you very much for that. I just thought I'd better
No,
mention that.
it's worthwhile. Thank you. Okay. So bring things to a close. Thank you. Thank you, Mr. Reynolds. Feels like a good opportunity to take a lunch break. Is everybody content with a like yesterday, perhaps a slightly shorter lunch break? If we adjourn till 15:15, would that suit everybody? About 50 minutes. Yeah, not seeing any expressions of horror, so we'll do that. We're adjourned now until 15:15, when we'll hear our next witness, Ms. Armstrong. Thank you. We're adjourned.